when the Senate goes into session. So I'm urging, especially if there's no opposition to the bill, that authors and witnesses in support be very concise. Any bills that we do not get to hear today will be put over until another hearing. So thank you so much. I believe we do have a quorum, and Madam Secretary, would you read the roll, please?
Hancock?
Here.
Hancock here. Anderson?
Here.
Anderson here. Calderon?
Here.
Calderon here. Harmon?
Here.
Harmon here. Liu? Price? Steinberg?
Okay. We do have an author. Assemblymember Swanson is here, so please come forward and present your bill. That is item number 2, AB 12. Welcome to the committee.
Morning, Madam Chair. Members of the committee, thank you so much. AB 12, the Abolition of Child Commercial Exploitation and Sexual Slavery Act, attacks the problem of child prostitution and exploitation at the most basic root. The men that, by raising the fine against men who are commonly known as Johns who pay to have sex with children. AB 12 would allow a judge the discretion to fine a John who has sex with a minor up to $25,000 and would use those funds to support programs that help commercially sexually exploited minors with wraparound services. The average age of girls entering into prostitution in California is 12 years of age. Some of them are victims of human trafficking. Some of them are victims of sexual abuse. Some of them are victims of abandonment and mental abuse, but all of them are victims. I would like my witnesses to self-introduce.
Hi, thank you. I'm Holly Joshi from the Oakland Police Department.
Okay, you can talk.
Chairperson Hancock and members of the Senate Public Safety Committee, my name is Officer Holly Joshi from the Oakland Police Department, and I want to thank Assemblymember Swanson for authoring AB 12. I'm here today to testify on AB 12, which will raise the fines against the Johns who pay to have sex with children. AB 12 will increase the fines against Johns to up to $25,000, making the fines similar to the civil fines available for statutory rape. I've been an Oakland police officer for 10 years, and although I have worked in many assignments, including patrol duties, burglary investigations, and undercover narcotics enforcement, even being selected by the DEA as a task force member for a 9-month drug cartel investigation. But nothing has affected me and touched my heart like the issue of human trafficking and the commercial exploitation of our children. I've been involved in combating this modern-day form of slavery since 2003, first being utilized as a street-level decoy targeting pimps and Johns, and then as a full-time investigator with the Child Exploitation Unit. There, I spent 3 years rescuing these girls from this bustling for-profit hell of sexual slavery. Much attention has been paid to the pimps who coerce or force these girls into this lifestyle. But I'd like to tell you that the customers commonly referred to as Johns are nothing less than sexual predators. Predators who seek out our children for sex, often driving for miles to our city streets and suburban motels to find them. These predators operate in a dark underworld and have their own subculture and language, using the internet to help one another locate and buy children, and also to advise one another how to thwart law enforcement and avoid detection by wives and loved ones. After paying pimps to repeatedly rape our kids, they usually return to their lives undetected, unpunished, or with a slap on the wrist, while the victims suffer emotionally and physically, and we, as a society, are left to try and undo everything they've done. So I thank you for your time, and I respectfully ask for your aye votes.
Thank you.
Good morning, Jennifer Baker with the California Teachers Association, and strong support of this measure. Teachers often witness the early signs and detect abuses that happen, and had often found situations where children that were in their classrooms were being used in this way, and so we very much support this measure.
Rebecca Gonzalez, National Association of Social Workers, California chapter. Obviously, social workers also see the effects of this kind of exploitation, and our organization considered this bill important enough to be one of our 3 top priorities in our lobby days this year, and we strongly support the bill.
Thank you. Others in support, and please be brief.
Kathy Sunderland with the County Welfare Directors Association in support.
Others in support? Are there speakers in opposition? Please come forward.
Liberty Sanchez on behalf of the public defenders, very regretfully here in very slight opposition to this measure. I've had some really fruitful conversations with the author's office in regards to this one outstanding concern we have. We think that many of the provisions in the bill are really wonderful and great steps forward. The only concern we continue to have is with the issue that there is a strict liability requirement in the bill. There's not a known or should have known requirement in regards to the age of the victim. So that is our one small outstanding concern, and for those reasons we regretfully still are registering our very slight opposition to this.
Thank you. Are there others in opposition? Seeing and hearing none, are there questions, comments, or would there be a motion from the committee? Senator Price and Senator Calderon.
Yeah, I just want to thank the author for his leadership on this, and for the witnesses, the officer and others who've testified, and who work in this world. It is really just so reprehensible and depressing, especially for those that are impacted directly or indirectly. And so I think this bill helps to address that issue, goes a long way, and I'm happy to move the bill.
The bill has been moved. Senator Calderon.
Yes, I just have a clarifying question. Hopefully, you have the answer. I'm reading in the analysis that any person convicted of soliciting or engaging in an act of prostitution where the person involved in the solicitation or the act was under 18 years of age, does that also mean will be fined? Does that also mean that if it's an underage child soliciting the prostitution, that they would also have to pay the $25,000 fine, or is this just on perpetrators?
Well, first of all, the $25,000 fine is up to the discretion of the judge. So you know that. So the decision of the court will be based on the circumstances in which the violation occurs, and so the court has that discretion.
But the bill does include the actual underaged. No, that's the way I'm reading this. Could we get maybe some clarification, Madam Chair? I'm reading on page 3 of the analysis, second paragraph. After existing law, it says this bill states that any person convicted of soliciting or engaging in an act of prostitution, that means on either side, where the person involved in the solicitation or act was under 18 years of age, it's a minor, shall be ordered by the court in addition to pay an additional fine not to exceed $25,000.
No, it's not. It is not the intent of the bill to the children of the victims of the crime, and so that's not the intent.
And I'm sure it isn't, but you'll have my support today for the bill. But I think as the bill moves forward, you might want to clarify that language, because oftentimes we have unintended consequences.
That's fine.
But the bill itself is drafted in terms of the adult who's seeking sexual services. It says any person convicted of seeking to procure or procuring the sexual services of a prostitute if the prostitute is under 18. So it's limited so that it's not, the fine wouldn't be imposed on the minor who is the prostitute in the case.
I want to make sure the minors are being...
Thank you. Thank you for that clarification, Senator Calderon. Any other comments? If not,
Madam Chair, just a clarification then. On page 5, The analysis, it's the second paragraph from the bottom. Perhaps the bill could be amended to provide that the additional fine can be imposed in a case where the defendant knew or should have known that the prostitute was a minor, indicating that it would be a scalable fine. Is that correct? I mean, I don't. What is?
It's up to 10.
It's up. I know it's up to. But the question is it? Does that occur in the bill?
You're talking. I think we're talking about the strict liability issue here.
Yeah.
We're talking about an 18-year-old or a 17-year-old young woman, and not a 10-year-old. Is there strict liability no matter what, or is it known or should have known for the additional $25 fine?
$25,000
fine.
Right.
Excuse me.
Well, first of all, yes, it is strict liability, and the reason why is because all this is taking place in an environment of an illegal activity. It's an illegal activity. I mean, they're involved with an illegal activity. It's like committing a felony and then committing a murder. It's felony murder. I mean, it's twice as bad. And so the fact that there's an illegal activity taking place, then you're liable. And if it turns out that this child is also that the victim is also a child, then you have strict liability there too. And so that's why the law is written the way it's written.
Does that answer your question, Senator?
Sort of, I guess. It's all right.
Well, you break into a store to rob the store.
I understand what you just said.
And the register is empty. You're still committing robbery.
Well,
Madam Chair?
Senator Calderon.
On the same subject, in the analysis, the committee is recommending an amendment that perhaps we provide an amendment that the additional fine can be imposed in a case where the defendant knew or should have known that the prostitute was a minor. So I don't know if you're referring to the amendment. Okay. And is that amendment being adopted?
No.
I believe that the author has indicated he does not.
Okay.
He will not.
It's not being adopted because these men are predators, and we have to show zero tolerance for these men. And so it's just unacceptable. I mean, they're already committing an illegal act, and now they're doing it with children. And normally, this is not a fine line on this question of children. By the way, I mean, we've in Oakland there's been kids as young as 10, and so this is just not acceptable.
Yeah, if I may say that. The fine is up to $25,000. I'm assuming the difference between a 10-year-old and a 17-year-old will be taken into consideration. But I understand the concerns of the committee. Yeah. Well, if there is not further discussion, the bill has been moved. It's a due pass to the floor. Madam Secretary, please open the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Calderon.
Aye.
Calderon, aye. Harmon.
Aye.
Harmon, aye. Liu, aye. Price. Price, aye. Steinberg.
Okay. We're putting that bill on call for other senators who are not here.
Thank you
very much.
Madam Chair and members of the committee.
Senator Padilla. Welcome.
Thank you, Madam Chair, members of the committee. Before this morning is SJR 7, which would affirm that the legislature of California supports both HR 308, the Large Capacity Ammunition Feeding Device Act in the U.S. House of Representatives, as well as S32, the Large Capacity Ammunition Feeding Device Act, awaiting in the United States Senate. And it would encourage the President and Congress to enact these acts. A little bit of a history for context here. On January 17th, 1989, at Cleveland Elementary School in Stockton, most of us recall an incident where Patrick Purdy fired more than 100 rounds in 3 minutes into an elementary schoolyard, killing 5 children, wounding 30 others, including 1 teacher. In that incident, he used an AK-47 equipped with a large capacity magazine. On July 1st of 1993, Gianluigi Ferri entered an office building in San Francisco and made his way to the 34th floor offices of Pettit and Martin. Upon entering the office, he opened fire with 2 Tec-9 handguns equipped with large capacity magazines, killing 8 people and injuring 6. 5 months later, in 1993, Colin Ferguson boarded the Long Island Railroad in Garden City, New York, and used his semi-automatic pistol and 4 large capacity magazines to kill 6 people and injure 19 others. This led to a groundswell of public opinion around the nation. Congress swiftly acted in 1994 by passing the Violent Crime Control and Law Enforcement Act, more commonly known as the Federal Assault Weapons Ban. And this act included a ban on large capacity magazines. The act in 1994 included a 10-year sunset. In 2004, Congress failed to renew the act, in effect ending the ban on large capacity magazines. And many of us recall not only a couple months ago, in January of this year, in Tucson, Arizona, when Jared Lee Loeffner used his Glock pistol equipped with a 30-round large capacity magazine to kill 6 people, including a 9-year-old girl and a federal judge. Among those injured was United States Representative Gabrielle Giffords. The shooter used a large capacity magazine to fire 31 bullets, and he was only stopped when he was reloading. Large capacity magazines were also used in other mass shootings since the lapse of the federal ban. Most notably were the shootings at Virginia Tech, where 33 were killed and 17 were wounded, and the Fort Hood military base, where 13 were killed and 34 were injured. I think these incidents clearly are the best examples of why a federal ban on large capacity gun clips needs to be reinstated. I don't believe large capacity magazines are necessary for hunting or self-defense. In the state of California, we already banned the manufacture, sale, and use of large capacity magazines. In 1989, this legislature passed the Roberti Roos Assault Weapons Act, banning assault weapons statewide. However, I believe a federal ban is necessary to ensure that magazines do not come into California from other states. That's what the federal laws proposed to do, and I believe it's important for the state of California, both with its legislative leadership history as well as history of tragedy, need to go on record in support of. With me in support of this resolution before you is Amanda Wilcox from the California Brady Campaign to End Gun Violence, as well as Ben Van Houten from the Legal Community Against Violence. I ask for your support.
Good morning. My name is Nick Wilcox, and I'm representing this morning the 22 chapters of the California Brady Campaign to Prevent Gun Violence. I don't want to take much of your time. I'll just reiterate a couple points. One is that a national ban is essential. We have had a ban on large capacity magazines in California for some time. That's helpful, but our states are porous, and we need to prevent them from coming in from other states. The analysis points out that only 6 other states have such a ban. That may be true, but I would also point out that in survey after survey, at least 65% of the public supports such a ban, at least on assault weapons, and then by extension, large capacity magazines. Finally, I would just point out that and this is somewhat of an admission, I grew up in a family of hunters and sportsmen. We had all kinds of firearms in our house, and my family engaged in hunting, and none of these weapons use large capacity magazines. Real hunters, like my brother, have given up using guns, and he uses a bow and arrow now.
So I'm Amanda Wilcox. I'm here on behalf of the Nevada County chapter of the Brady Campaign to Prevent Gun Violence. Nevada County had their own experience of a rampage shooting where a large capacity magazine clip was involved. A little over 10 years ago, my daughter was killed. She was shot 4 times at point blank range by a person with a semi-automatic handgun and a 30-round clip. And others were injured and wounded. A ban would not have saved my daughter's life. She was the first one shot. But certainly other individuals who are injured or killed, their lives could have been changed or perhaps saved, an injury avoided if there had been such a ban. It's very clear that a large capacity ammunition clip allows for a higher more quickly killing more people, I think, to put it succinctly. One of the arguments, of course, is for the self-defense, and I would say that for those who feel that they need a gun to protect themselves in the home, a 10-round clip should clearly be able to do the job of self-defense. In fact, we often hear from the opposition that just brandishing a weapon provides self-defense. So I think a 30-round clip is unnecessarily for that use, and a large capacity magazine is clearly for offensive purposes, for killing more people more quickly, and not for defensive purposes. Thank you.
Thank you. Thank you for your testimony on so many issues and for your work. Are there others in support?
Good morning. Ben Van Houten on behalf of Legal Community Against Violence. Legal Community Against Violence was founded after and in response to the shooting at Pettit and Martin that Senator Padilla described. This is an extremely important issue for us, and large capacity ammunition magazines are the common thread uniting all of the major mass shootings. There is simply no reason that these magazines should be available on the consumer market.
Thank you. Are there others in support? Are there speakers in opposition? Please come forward. And I think that the proponents were fairly brief, so please be, yeah.
Senator, members of the committee, Ed Worley with the National Rifle Association. What we're trying to enact here, or what we're trying to support here, is a failed policy on the federal level and also on the state level, too. If you remember, if you look back at current state law, high-capacity feeding devices or high-capacity magazines aren't banned in the state of California. You can get a permit to purchase one. The movie industry gets permits to purchase one all the time. There's an exemption for law enforcement to purchase high-capacity feeding devices or magazines for their own personal firearms that have nothing to do with the firearms that they use in duty. Currently, anybody who owned a high-capacity magazine before the effective date of the California so-called assault weapons ban, which is also not a ban, can lawfully keep those in their possession and can lawfully have those. So when we throw on the word ban in this building, which we have a tendency to do because it sounds good, people need to understand that the ban they're talking about here is not even a ban. The federal level wasn't a ban. The federal level said that if you had the high-capacity feeding device before the effective date of the law, you could keep it. You couldn't buy any new ones or trade any new ones. So what we're doing in this is we're implementing a failed federal policy again. So that's why we would ask you not to support this resolution. Thank you very much.
Thank you.
Good morning, Madam Chair, members of the committee. Tom Pedersen, representing the California Rifle and Pistol Association. There are a number of reasons we're opposed to this particular resolution, in that there are a number of legitimate reasons to own firearms that are capable of holding magazines with more than 10 rounds. Case in point is the standard service rifle matches that are held in the United States are held with the AR-15, which is technically considered an assault weapon, although it's just a matter of terminology. It's a semi-automatic rifle, self-loading rifle. And there are also a number of manufacturers that manufacture those types of firearms now for sporting use, for hunting particularly. And so those particular firearms do have magazines capable of holding more than 10 rounds. And although we're very sympathetic towards any individuals that have suffered due to these few tragedies that have occurred, I think we have to remember that the number of magazines out there in circulation number in the millions, and the actual problems that result are so minuscule as compared to the legitimate use of such implements. So for those reasons, we would request that you vote no. Thank you.
Thank you.
Hi, Elenia Helmantola, Responsible Citizens of California. I am a competitive shooter in IDPA and Steel Challenge. Both of those, we use standard reduced capacity magazines. Here in California, we don't have even standard round capacity magazines. We have what's considered reduced capacity. Reduced capacity is 8 to 10 round magazines. Now, I go through 200 rounds in a shooting competition within a very short period of time. For that purpose, you still need a high-capacity magazine in order to be competitive with other competitors. Now, the other thing is when you're doing cross-state challenges and you're doing other states, they have a direct advantage, which means California will never come in first in shooting competitions because we are not trained with the high-capacity magazines like other places. So there are sporting purposes in which we use high-capacity magazines or where those would have a sporting purpose. High-capacity magazines currently, there's rebuild kits that are available and people can still make them regardless of whether or not there's a ban on them. So you're not going to prevent those that are already out there. And for that reason, we are opposed to this bill.
Thank you. Are there other speakers in opposition? Seeing and hearing none, are there questions? Oh. Yeah.
Madam Chair and members, Sam Paredes, representing Gun Owners of California. For all the reasons stated, we are in strong opposition to this measure. Thank you.
Thank you. Are there others in opposition? Seeing and hearing none, are there questions or comments from the committee? Or is there a motion on the bill? The bill has been moved by Senator Price. Would you like to close, Senator Padilla?
Senator Calderon, I get them confused all the time, too. I think the questions and discussion in this committee reflect how straightforward the issue before us is. Not that it's not controversial, not that there's differences of opinion, but I think it's pretty straightforward. Just a couple of items in response to some remarks made by those who spoke in opposition. I want to make it very, very clear. What we're supporting here is the restriction on the magazine clips. The weapons, they're obviously related, but that's a different issue. I do take issue with the gentleman who insisted that this is a failed policy. I think statistics show differently. I failed to mention in my presentation the SB 23 by Senator Parada. I mentioned the Roberti Roos assault weapons ban. The Parada bill was a large capacity magazine ban in the state. And since the enactment of that bill, there haven't been any of these mass shooting tragedies within the state of California. So I think statistics do speak for themselves. And finally, the argument that, well, this isn't an outright ban, so don't call it a ban. There's exceptions that are made. You know, the law enforcement was one of the examples. They're absolutely right. It's not an outright ban. It's a 99.9% ban with special circumstances that allow for someone to obtain a permit for purchase of a large magazine. But just that very process in itself is a huge control that I do believe has led to reduced violence, reduced incidents, reduced victims in the state of California. So the record does speak for itself, and I would ask for your vote.
Thank you. Madam Secretary, would you open the roll?
Hancock?
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Calderon?
Aye.
Calderon, aye. Harmon?
No.
Harmon, no. Liu?
Aye.
Liu, aye. Price?
Aye.
Price, aye. Steinberg?
Okay, that bill is out, but we'll hold the roll open for any additional members. Thank you.
Madam Chair, would you consider
yes.
doing the consent calendar now?
I would. Thank you, actually. We do have 4 items on the consent calendar. Item number 4, AB 332. Item number 6, AB 708. Item number 7, AB 886. And item number 10, AB 1281. Consent calendar has been moved. Secretary, please open the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Calderon?
Aye.
Calderon, I. Harmon. Harmon, I. Lou. Lou, I. Price. Price, I. Steinberg.
That bill is out for the consent calendar. Okay, we will move to item number 8. I believe that Assemblymember Knight is here.
And then we'll take Assemblymember Adiano.
No, he is not here. Yes, but Assemblymember Amiano is here as well.
So we were
And
going to
he's
take them in this order.
Yes, we were, but he's not here.
I understand.
Okay. Amiano. I'm sorry. The sergeant did not. I guess you haven't been here for this committee. Assemblymember Knight is here. Yeah, okay. Please come forward and present your bill.
Thank you, Madam Chair. Members. Assembly Bill 1026 will make it easier for prosecutors and defense attorneys to determine whether or not a defendant's prior conviction for assault with a deadly weapon statute involves situations where a defendant commits an assault on a person with a deadly weapon, or a situation where a defendant commits an assault on a person likely to produce great bodily injury. Under existing law, Penal Code 245A1, an assault with a deadly weapon can be treated more severely than an assault likely to produce great bodily injury. This currently causes problems by clogging the court system with cases because the true nature of the conviction is not known at the time. AB 1026 will allow for a more efficient assessment of a defendant's prior criminal history and will lead to a more accurate and earlier disposition of criminal cases by deleting Penal Code 245A1 and placing it in a new subdivision so that in the future this problem will be clear to address in court. This bill does not create any new felonies or expand the punishment for any existing felonies. It merely splits an ambiguous code section into two distinct parts. I'm pleased to have Dan Filizzato with the Los Angeles County District Attorney's Office to answer any technical questions you might have. And this bill has passed with no votes.
Right. This is a bill that we're thinking can pass expeditiously here as well.
I'm with you.
The bill has, in fact, it's been moved, but let's just see if there's any opposition. Are there any additional speakers in support? Are there speakers in opposition? Seeing and hearing none, the bill has been moved by Senator Calderon. Any comments or questions from the committee? Would you like to close? Assemblymember Knight. Secretary, please open the roll.
Hancock.
Aye.
Hancock, I. Anderson.
Aye.
Anderson, I. Calderon.
Aye.
Calderon, I. Harmon.
Aye.
Harmon, I. Lou. Lou, I. Price. Price, I. Steinberg.
That bill is out.
Now we will take Assemblymember Gato is here, and Assemblymember Ariano has been waiting.
Okay. Next on file order is Assembly Member Gatto, item number 5, AB 547. I believe that this should go fairly quickly as well if the Assembly member is willing to accept the amendments suggested.
I am indeed,
in the
Madam Chair.
analysis. Thank you for your statement of intention, but you may open.
Brief presentation. Thank you, Madam Chair. I'm just presenting AB 547, which is an elder protection measure. It makes it a misdemeanor for anyone to coerce or deceive an elder in a state licensed institution or program into voting for someone or something against their will. I want to thank the Chair and her excellent committee staff for their amendments, which I'm happy to take, and I respectfully ask for your vote.
Okay. Thank you. Are there... Pardon? Yeah. Okay. Let staff quickly.
Let me just say them so they're on the record. So we talked yesterday about instead of 10,000 for each vote cast, it'll be 10,000 for each ballot.
No,
up to 10,000
per voter to see.
Okay.
Yeah.
And then there's going to be a 6-month jail sentence, so it's not a fine, only misdemeanor, and then also a savings clause, so if there's an overlapping section, the prosecutors can choose to do that one.
Perfect. Yes. Thank you.
Great. So the motion is to pass as amended to appropriations.
Madam Chair, just out of curiosity, who's going to monitor this?
I believe it would be like a lot of other vote-related crimes. It would be based on a complaint system. It would be if someone, someone has an issue in one of these institutions, they could then call a hotline that a lot of the DAs provide, and just share with someone, hopefully in a confidential manner, that they have been the victim of a crime like this.
Okay, because we're talking about elder abuse, right?
Correct.
And because I see a similar situation happening in the human services side, in these skilled nursing homes, et cetera, and I didn't realize that there was a central hotline that folks could call. The DAs have?
Some DAs have hotlines. I'm not sure if they're active during the entire year, but I've seen some posters at places where DAs say if you're experiencing any problems connected with voting, call this number. And I don't know about all the practices in all the counties, but
okay, I was just curious.
we have DA's office here.
Senator Lou, Dan Phillips on behalf of the Los Angeles County District Attorney's Office. Typically, these type of incidents reports either go to the Secretary of State's office because it's voting. Sometimes people will refer it to Adult Protective Service or to the DA. When these cases are referred to the Secretary of State or to Adult Protective Service, both those agencies typically, especially in LA County, I would imagine around the state, simply refer those cases to the district attorney for investigation.
Right. Okay, but who makes the initial call? And it would be somebody just kind of serendipitously falling upon this information. It's not.
I would hope that. I think what you're touching on is that we have certain crimes that are more difficult to report, and these certainly are ones that are difficult to report. Sometimes we hear these reports through the son or grandson or daughter or granddaughter of someone who's in a facility, and sometimes it's the elder themselves who are courageous enough to step forward. And I think what you're getting at is we need to make it easier for people to report some of these crimes, because some crimes are not reported as much as others.
Okay, thank you.
Typically, we get family members. Sometimes we even we'll see precinct election workers when a senior is acting confused and ask for assistance. Other times, you'll get referrals from anonymous good citizens.
Okay, thanks.
Thank you. Are there other comments or questions from the committee? The bill has been moved to pass as amended to appropriations. Secretary, would you open the roll?
Yes. Hancock?
Aye.
Hancock, aye. Anderson? Calderon?
Aye.
Calderon, aye. Harmon?
Aye.
Harmon, aye. Lou?
Aye.
Lou, aye. Price?
Aye.
Price, aye. Steinberg?
We will hold the roll open. The bill is out. Thank you very much. Assembly Member Amiano, AB 1081, Item 9.
Madam Chair and members of the committee. Is this on? Yes. The controversial Federal Secure Communities Program, also known as ESCOM, automatically checks the immigration background of every individual at the point of arrest by sharing fingerprint data with U.S. Immigration, Customs, and Enforcement, ICE, enabling ICE to detain and deport immigrants without the basic right to a day in court. The stated mission of the ESCOM program is to target serious offenders. However, in California, 70% of deportations are people without criminal records, including victims of domestic violence or people charged with lesser offenses, including misdemeanors. Contrary to its goal, ESCOM has actually harmed public safety and seriously undercut community policing strategies. Under ESCOM, victims of a crime, including survivors of domestic violence, are unwilling to risk separation from their families and deportation by cooperating with local law enforcement. Due to these harmful effects of ESCOM, criticism of this program is drastically expanding nationwide. Illinois, New York, and Massachusetts have terminated, suspended, and refused participation in this troubled program. Californians also deserve to have their rights protected. AB 1081 requires the California renegotiate our agreement with ICE to allow counties to opt into the program and ensures that these localities participating in ESCOM will have a plan to prevent racial profiling, prevent children and crime victims and survivors of domestic violence from being wrongfully targeted. It is extremely important to highlight two issues. This bill does not change the current process of the collection of or checking of fingerprints for criminal information. So even if a county does not participate in ESCOM, the fingerprints from the county will still be run through the state and federal database for criminal background checks. AB 1081 does not take away any federal funding because participation in ESCOM is not required to obtain federal funding. This bill gives counties the flexibility to spend their limited resources on public safety efforts and that actually make our communities safer. Here with me today to testify on behalf of the bill are retired Police Chief of Sacramento, Arturo Benegas, and Rene Salcedo, who will be reading the testimony of Norma, a survivor of domestic violence harmed by ESCOM, who unfortunately could not be here today.
Thank you, Assembly Member. Honorable members of the committee, thank you. My name is Art Venegas. As I was introduced, I'm the retired Chief of Police for the City of Sacramento, served in that capacity for over 10 years. And currently, I am the Director of the Law Enforcement Engagement Initiative. It's an initiative, national initiative, engaging law enforcement executives on a sensible dialogue on immigration and immigration reform. You actually have before you my statements, as well as comments made by chiefs and sheriffs on a national level on their concerns about secured communities. I would like to point out, though, a couple of items in your request, Madam Chair, to keep it brief, but that I think are very, very important. In regards to secured communities, law enforcement across the nation were told that this effort was really to target the serious offenders that were coming into the institutions, either at the local or the state level. And in fact, law enforcement across the country recognizes the need really to not only identify but apprehend, prosecute, incarcerate, and actually have them do the time before deportation of the serious habitual offender. That's number one. Nobody argues. Everybody in our communities across the country desires that. In addition to that, however, we also have fought racial discrimination and profiling for a long, long time. What we have discovered is that secured communities, and we call it the Trojan horse, enables individuals actually to allow their biases to come out. And in fact, what we have discovered across the country, and you notice that from the statements, is that the vast majority of the individuals that are getting arrested either have committed no crime, or their offenses are so small that they were not the original targets. And as indicated in here, it's actually higher percentage, and those are Department of Homeland Security, ICE numbers. Additionally, I think for us, and no news to you, the number one item is our budgets. I know that my colleagues here in Sacramento and across the country are fighting devastating cuts. They just recently announced here within the city of Sacramento the fact that they have to lay off 80, 90 police officers, and I know Sheriff Jones is in the same boat. You folks are having to deal with the devastated change of having to release 43,000 inmates that are now going to be coming back into our communities. That said, we also recognize that the incarceration of a lot of these folks is really falling on the pockets of the local voters and the state. And the reality is that it is a very expensive proposition and ludicrous for the federal government to expect local and state governments to fund their program. And it is devastating at the same time. The relationship that took us years to build with community policing. And we cannot afford to have a large segment of the community out there be afraid to participate in the safety and security, not only of our communities, but of our country. Thank you.
Thank you.
Statement of Norma, member of Mujeres Unidas y Activas in San Francisco, California. My name is Norma. I intended to be present for the hearing, but I have come up with the flu. I will try to tell my story, but it cannot be summarized in a few words. I'll try to be brief. Prior to October 2010, my ex-partner hit me several times. I never called the police because of fear. All that changed in October 2010 in San Francisco when I finally had the courage to call the police after he hit me again. When the police arrived, my ex-partner yelled at me and falsely accused me of hitting him. The police arrested both of us because they did not know who to believe and took us to the police station for further investigation. After talking to the police dropped criminal charges against me. But to my horror, the police locked me up. I was so scared not knowing what would happen to my 3-year-old child while I was in jail. I later discovered that I had an immigration hold, even though no one told me what was happening. After 5 days in jail, I was transferred to ICE. There, I was taken in handcuffs to a room. Someone from ICE asked me if I wanted to be deported voluntarily. I was scared and did not want to answer, and told the ICE agent that I wanted to talk to a lawyer. I am now in deportation proceedings with the immigration court. A few days after this incident, I learned that the reason that I was transferred to immigration, even though I reported the crime, was because of the Secure Communities, or SCOM. After I was arrested, the police took my fingerprints. Through SCOM, my fingerprints were sent to ICE. Immigration then issued a detainer. Because there was an ICE hold, the police did not allow me to leave, even though they dropped criminal charges. Secure Communities does not make me more secure. Survivors of domestic violence should feel safe reporting crimes. But why would anyone ever call the police about a domestic violence incident if the victim risks deportation? How can anyone risk losing their child? For women suffering domestic violence, SCOM will be a deterrent to seeking help from the police, and abusers will have another way of continuing their violence with impunity. I will fight my case, and I have since learned a lot of my rights in recent months. The Trust Act is a first and important step to ending SCOM in our communities. We should demand that authorities take into account the operation of its own programs like SCOM and how they really work, not how they are billed in the press. I do not want to see another woman going through the same situation that I did, which is why I am coming forward to tell this story. Thank you for your attention.
Thank you. Others in support? Are there other speakers in support? I would ask you to be very brief, please. You could speak at that microphone over there or right here. And just if you say your name and where you're from and your position on the bill.
Good morning. My name is Maistela Hantouche. I'm with Casa Justa Just Cause. I'm from Oakland, California, and I'm in support of the Trust Act. Thank you.
Hi, I'm Rabbi Dr. Catherine Hanwin Rashida Zittler. I represent many Jewish organizations, interfaith coalition, and conservative groups. I stand in support of this bill.
Esther García. Mi nombre es Esther García.
A little closer to the mic.
¿Se puede acercar un poco más al micrófono, por favor?
Vengo a presentar Unicentro Montevideo.
My name is Esther Garcia, and I come from Mountain View, and I support this bill. Gracias.
Gracias. Y vengo por que voten por el 1081.
Yes, thank you. I come in support of 1081. Thank you.
Good morning, honorable members of this committee. My name is Maria Marroquin. On behalf of the National Day Labor Organized Network, I strongly and respectfully urge you to support 1081. Thank you.
Hello, my name is Jill Malone, and I represent PACT San Jose, as well as the 500 congregations, schools, and community groups in Pico, California. We strongly support this bill.
Hola, mi nombre es Ana Ponce y venimos representando al Day Work Center de Mountain View y venimos a pedirles que apoyen la ley 1081, por favor.
My name is Ana Ponce. I come from the Day Labor Center in Mountain View, and we're here today to support this bill.
Mi nombre es Wilber Ramírez. Vengo del Day Work Center de Mountain View. Y por favor le pedimos que apoyen la ley 1081.
My name is Wilbur Ramirez. I'm from the Day Labor Center in Mountain View, and we're asking you to please support this bill.
Buenos días, mi nombre es Juan Antonio, represento al Day Worker Center de Mountain View y pido por favor que se apoye la propuesta 1081.
Good morning. I'm from the Day Worker Center in Mountain View, and I ask that you support 1081.
Yo, Cristóbal Sánchez Acamba, vengo en representación de Santa Cruz en el centro de Orlanero y pido que se apruebe la ley 1081.
I'm here representing the Day Labor Center in Santa Cruz, and I ask that you pass this bill.
Mi nombre es Santiago Barbosa, soy miembro de Causa Justa de San Francisco y con todo gusto pido que apoyen la propuesta. Gracias.
I'm Santiago Barbosa. I'm with Just Cause in San Francisco, and I urge you to pass this bill.
I'm Cynthia, and I work at Just Cause. We work in San Francisco and Oakland, and we're also urging you to pass this bill.
Hello, everybody. My name is Billy Trice Jr. I'm from Cruces as a Just Cause from the San Francisco Bay Area, and I support the Trust Act because there are indigenous immigrants that came here because they were displaced by their homeland. Thank you very much.
Buenos días, mi nombre es Araceli Catalán, soy miembro de Causa Justa San Francisco y vengo a apoyar la acción.
Good morning, Araceli Catalan from Just Cause in San Francisco. I'm here to support this bill.
Good morning, my name is Joseph Villela on behalf of the Coalition for Humane Immigrant Rights of Los Angeles, in strong support of this bill.
Good morning, Gabriela Villarreal, California Immigrant Policy Center, in strong support of this bill.
Good morning, mi nombre es Bayardo Centeno, soy de San Francisco y ando en apoyo al acta de confianza. Vengo de parte de Causa Justa.
Bayardo Centeno, on behalf of Just Cause in San Francisco, I urge you to support this bill.
Good morning, my name is Maria Hernandez, and I come from San Francisco. I strongly support this bill.
Thank you. Morning, my name is Delfina Hernandez. I'm from San Francisco and representing the collective women's, and I support the bill.
Good morning. My name is Jeanette Snepatin, Legislative Staff Attorney with the Mexican American Legal Defense and Educational Fund, in strong support.
Good morning, everyone. My name is Ana Avalos. I just graduated from Mission High School. I'm an attendant to UC Santa Cruz, and I come here today to respectfully ask you for your aye vote. Thank you so much. Muchas gracias.
Hola, buenos días. Mi nombre es Erika Hernández. Vengo de San Francisco de la colectiva de mujeres y apoyo la 1081.
My name is Erika Hernandez. I'm with the Women's Collective in San Francisco, and I support this bill.
Buenos días, mi nombre es Dora, vengo de San Francisco de la colectiva de mujeres y vengo que apoyen la 1081. Gracias.
Good morning. My name is Dora. I'm with the Women's Collective from San Francisco, and I urge you to support this bill. Thank you.
Buenos días, mi nombre es María Fernández de la Raza Centro Legal y pedimos que apoyen la 1081. Gracias.
Good morning, María Fernández with the San Francisco Day Labor Program and La Raza Centro Legal. Please support this bill. Thank you.
Buenos días, mi nombre es Petra Rosas y soy miembro de la colectiva de mujeres de San Francisco y apoyo la AB 1081.
Good morning, my name is Petra Rosas. I'm with the Women's Collective from San Francisco, and we are here to support this bill.
Buenos días, mi nombre es Juvencio Reyes, vengo apoyando la propuesta de Turno Anguiano.
de Jornaleros de San Francisco.
Good morning. My name is Juvencio Reyes. I'm with the San Francisco Day Labor Program, and we're here to support Assemblyman Amiano's bill.
Hi, good morning. My name is Hannah Paulmeyer. I'm also from the San Francisco Day Labor and the Women's Collective programs, and I'm also here in strong support of this bill. Thank you.
Hi, good morning. My name is Jose Gutierrez. I come to support the act. Okay, thank you.
Liberty Sanchez on behalf of the California Public Defenders Association in support.
Madam Chair and members, Caitlin Vega for the California Labor Federation, also here in support.
Francisco Dominguez. I'm a documentary photographer. I live here in Sacramento. And racism and racial profiling has no place in our society. I strongly urge you to support Mr. Amiano's bill. Thank you.
Steve Wallach on behalf of the Alameda County Board of Supervisors and the Berkeley City Council in support.
I'm an Emerald Torres and coming from represent the Grayton and I support the bill.
Michael Radigan on behalf of the Board of Supervisors, Santa Clara County, here in support.
Buenos días, mi nombre es Heriberto Pérez y vengo en representación del Centro Laboral de Grayton y apoyo a la AB 1081.
Good morning. I'm representing the Grayton Day Labor Center, and I'm supporting this bill.
Hola, mi nombre es Juan Cuandón, por la Labor Center Grayton, Sonoma County, a favor de la 1081.
Juan Wandon from Grayton, California, in Sonoma County, also here to support this bill.
Omar Gallardo, part of also the Grayton Day Labor Center and the North Bay Organizer Project in Sonoma County, also in strong support of 1081.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support of the bill.
Tiffany Mock on behalf of the American Civil Liberties Union in strong support of the bill.
My name is Angela Chan. I'm a staff attorney at the Asian Law Caucus, and we strongly support this bill.
I'm Renee Saucedo. I'm an attorney and organizer with La Raza Centro Legal, and we strongly support this bill.
And I want to thank you for your translating, too. That was extremely helpful to us. Are there other speakers in support? Are there speakers in opposition to the bill? Please come forward. You can have a seat at the table if you want.
Good morning, Madam Chair. Curtis Hill on behalf of the California State Sheriff's Association. We are in opposition to this bill. However, I'd like to thank the author, Assemblyman Amiano, that we've done a lot of good work. Sheriff Hennessy of the Sheriff of San Francisco County is in support of this bill. He's worked with the Assembly member to have some amendments to the bill, in particular the issues that we were very concerned with regarding profiling and also the hand separating of the fingerprints as they moved through our local adult facilities in California. We're still in opposition, however. I want to thank Mr. Amiano in that we have continued and will have continued discussions as far as potential amendments for him to consider as the bill moves forward. But at this point, State Sheriffs is in opposition. Thank you.
Thank you. Other speakers in opposition? Seeing and hearing none, are there comments or questions from the committee or a motion? Senator Calderon.
Yeah, thank you, Madam Chair. I want to thank Assemblymember Amiano for bringing this measure forward, and as Vice Chairman of the Latino Legislative Caucus, I just want to share my concerns, having personally received concerns from constituents, civil rights organizations, and other elected officials that are deeply troubled and concerned over what we have all come to know as a deeply flawed federal immigration enforcement policy. The Secure Communities Program, as they call it, ESCOM, was created by the United States Department of Homeland Security to address what some believe to be a growing problem of violent crime committed by undocumented persons. Its purpose was for the Immigration and Customs Enforcement to work with local law enforcement to share biometric information for those that have been charged or convicted of a crime. Instead, what we are hearing today, what's resulted is a seriously flawed policy that has led to that has led to work with local law enforcement to share this information and the deportation of innocent immigrants is occurring, which was these are people that have never been convicted of any crime. While the ESCON was directed at violent offenders, I think you heard in today's testimony, more than 2/3 of those have been deported were merely charged or convicted of a minor offense, such as a traffic violation. It's not new to any of us here that sometimes what we perceive as a well-thought-out public policy results in unintended serious consequences. So today I am voting to support AB 1081 because it does not eliminate the partnership between local communities and ICE, and merely provides the counties that wish to participate satisfy very reasonable safeguards. With that, I ask the committee for their support of this bill.
Thank you, Senator Calderon. Senator Price.
Yeah, I too want to thank the Assembly member for his leadership on this effort, and for the broad coalition of human rights organizations, labor unions, businesses, individuals who are stepping up. You know, racial profiling is wrong wherever it occurs, however it occurs, and so I'm pleased to support this bill and would encourage my colleagues to do likewise. Thank you.
Yeah, I believe Senator Calderon moved the bill. So the bill has been moved. For all the reasons mentioned, I'm delighted to support the bill as well, and thank you. Thank you so much, Assemblymember Amiano, for bringing the bill forward. The reasons, the statement of Senator Calderon was right on target. Also, I very much appreciate having Mr. Venegas here. As a police chief, you know, and as a local government official, I know I worked for years to build the trust between the community and the police that you get from a community policing policy, truly making our streets safer. And for that to be shattered or threatened in any way is something we cannot afford to have happen in this state when we have to be so careful setting priorities to truly make our streets safer. So I would like to be added as a co-author as the bill moves forward, and I thank you very much and thank the people who came today and took time out of your day to come all the way to Sacramento to testify. Okay. Senator Calderon?
Yeah, I would like to be added as co-author if possible.
I would also.
And Senator Price as well. Great. Seeing no other comments or questions, Secretary, please open the roll for a vote. The motion is due pass to appropriations.
Hancock?
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Calderon?
Aye.
Calderon, aye. Harmon?
No.
Harmon, no. Liu?
Aye.
Liu, aye. Price?
Aye.
Price, aye. Steinberg?
That bill is out 4-2.
Thank you very much.
Thank you. The last bill on our schedule today is Assemblymember Fuentes.
Is that the last bill?
Fuentes is the last bill, but while he's coming, I thought I would lift the calls. Okay, item number 1.
No, the deal was the second one. Swanson. Yeah, I think we're okay.
Item number 1 passed 4-2. Item number 2, AB 12 by Swanson. Senator Anderson?
Aye.
Aye.
Wait.
Oh, I'm sorry.
To lift the
call. Okay. Secretary, please lift the call.
On agenda item number 2, which is AB 12, Anderson?
Aye.
Anderson, aye.
Okay, that bill is out. 6-0. Item number 3, was pulled by the author. The consent calendar. I don't think everybody was here for the consent calendar.
There we go.
Item 5.
Move the bill. Just kidding.
Okay, we're just going to finish here. Item number 5, Assemblymember Gatto, AB 547. Secretary, please lift the call.
Anderson.
Oh,
AB 547, agenda. Anderson, aye.
Okay, that bill is out, 6-0. And that's it. Thank you. Assemblymember Fuentes.
Thank you, Madam Chair. Today I'm presenting on Assembly Bill 1358, which is a bill that would bring in much-needed revenue to the courts and counties choosing to participate in this voluntary program. Last year, as part of the budget, the legislature adopted a one-time amnesty program for infractions. The program established a 6-month window where individuals who have failed to pay infraction fines and penalties may pay 50% of what they owe and be released from further liability. That program is mandatory and is scheduled to be implemented in 2012. AB 1358 is based on a similar successful amnesty program which was implemented in the early 90s and would allow counties and courts to include certain vehicle code misdemeanor fines in their 2012 amnesty program. Currently in California, a large amount of fines, fees, and penalties issued by the courts go uncollected. Many defendants would like to pay what they owe but are financially unable to do so. Amnesty programs provide incentive for these individuals to pay a portion of what they owe so that the courts and counties may get an infusion of cash, which would otherwise remain uncollected, and have that added benefit of helping clear the court's dockets. It's important to note that this bill does not allow amnesty for certain misdemeanors such as DUI or reckless driving where an injury has occurred. The bill is completely discretionary on the part of counties and courts. Only those who want to incorporate the allowable vehicle code misdemeanors into their infraction program would do so. This bill will serve to bring in some much-needed revenue to the counties and courts choosing to participate. Today I have witnesses in support, Madam Chair, and I urge an aye vote.
Thank you.
Liberty Sanchez on behalf of the California Public Defenders Association, the sponsor of this measure. We think this measure is a win-win for counties and courts. Obviously, we're in a fiscal crisis, so every dollar that can be brought into local coffers will go a long way. These are dollars which otherwise would go uncollected. My colleague will testify to the specifics of how bad it is in LA. But not only do these dollars go, uncollected, but when people are brought in on a warrant and are unable to pay the back fines and penalties that they owe and are forced to stay in jail, those are additional costs that are borne by the localities. Once again, this measure is completely discretionary on the part of localities, even though the bill has a limited enumerated list of vehicle code misdemeanors, excluding, of course, DUIs, reckless driving where there are injuries, etc. A county or court that chooses to include this in their mandatory program can further limit the list of vehicle code misdemeanors so that it's whatever list they're comfortable with. When this was implemented in the 90s, it brought in a huge amount of money to the counties that chose to participate. For those reasons, we're strongly in support and request your aye vote. Thank you.
Thank you. Others?
I'm ready to move the bill.
Okay, so be brief, please.
Madam Chair, members, Dan Phillips on behalf of Los Angeles County District Attorney's Office. Just so that people understand the extent of the problem, in Los Angeles County, we have over 1 million bench warrants for these types of criminal activity. We would hope to be able to clear the vast majority of those bench warrants. Thank you.
Thank you.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support of the bill.
Thank you. Others in support? Speakers in opposition? Seeing and hearing none, the bill has been moved by Senator Anderson. Any comments from the committee? Secretary, please open the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Calderon? Harmon? Liu? Aye. Liu, aye. Price? Aye. Price, aye. Steinberg?
5-1.
No, 4-0.
4-0.
The bill is
The bill is out.
Thank you, Madam Chair.
You can lobby Senator Calderon for his fourth vote. The committee meeting is adjourned.